I purposely didn't contribute on social media with any of my opinions about the Alex Murdaugh trial when it was going on because I wanted to sit back and observe it and digest it before offering opinions. Plus, social media had an onslaught of people offering their opinions seemingly moment to moment. I don't know how they were able to do it, but I had other things to do. Now that I've had time to reflect, here's one thing I want to offer. People are on the fence about was it good strategy to have him testify or not. Long before the Alex Murdaugh trial, when I used to try criminal cases, more often than not I would encourage my clients to testify for one simple reason. If our theory of defense is actual innocence, meaning I definitively didn't do it, then jurors expect for them to testify. If your theory is just the state can't prove their case, there's reasonable doubt, you probably might not need to take that risk. And yes, the Constitution affords every criminal defendant the right to remain silent. And we tell jurors in voir dire, and the judge instructs them, you're not to draw inferences from someone not testifying. But there's a difference between what you should expect under the law and what reality is. We're all human beings. We don't leave our common sense and life experience at the door. Jurors walk in, and if they hear a lawyer tell them my client is 100% innocent of the crimes accused, they want to hear from the defendant. Barring some extreme circumstances, I've usually counseled my clients to testify. I can remember one case in particular in Miami-Dade County. There was half a dozen, if not more, criminal charges, all of which combined could have led to life imprisonment for my client who was less than 30 years old, armed drug trafficking, possession of all kinds of narcotics. The facts were not very favorable. In fact, I think I was the fourth or fifth defense attorney who took the case. Everybody thought I was crazy, thought it was a dead bang loser, and there's no way I could win the case. We got him acquitted on every single charge, and he testified in that case, despite the fact that he had tattoos of AK-47 bullets on his fingers and a whole number of other things that other lawyers had interpreted as bad facts. Why? My theory of defense was that the client was actually innocent. He happened to be in a place watching the Heat, the Miami Heat, play for an NBA championship with a bunch of his friends while the place got raided. Just being in a place where criminal activity may be going on doesn't make you a criminal. The jury understood that, and a whole host of other things that I could delve off of once my client testified, almost reassuring the jury that he had nothing to hide.